Consent, this is another thing which we should be very much focusing upon. The consent should be taken, or patient gives the patient gives the consent. It should be always taken before the examination. Informed and written consent should be there. Patient or the legal guardian sometimes give the consent, or it should also be taken in duplicate, and valid consent is given by a person who is above 18 years. It is a very big topic, consent, and I would like to point out some of the things like it is a contract between two persons who agree upon same thing in same sense, and consent should be free from coercion and fraud, misinterpretation and mistakes. Consents can be implied consent, means understood consent. We can say that if the patient is coming to us and we developed eye contact and we developed an understanding, in that we can do certain part of the examination, but we should avoid examination of the orifices and the private parts. For that we should be having an informed consent or express consent in the presence of a witness. Express consent can be verbal consent. Verbal consent should be present in the presence of a witness or disinterested parties. Sometimes patient is alone, and disinterested parties can be your attendants. Hospital attendant can act as a disinterested party. Written consent, it is again in the written form, and we should be having a witness for that. Both are equally valid, your verbal or written, but the witness should be present in both. Different parts of the consent is competence, and one part is competence and capacity, means the mental capacity should be there to give the consent. Person should be of sane mind, person should have good knowledge, or a person should be aware of himself, not mentally disturbed, not comatose, any mental disease, or age should be proper to give consent. Proper age should be there to get the consent. Then again we have, if certain procedures are going on, if we are performing certain procedures, certain examination, we should disclose all the things, like sufficient information should be include uncertainties about the diagnosis. It is about the treatment option, investigation prior to procedure, material significant involved, common or serious side effect, expected outcome, including benefit, limitations, alternatives to procedure, consequence of not having the procedure, or procedure will carried out by the patient consultant or his it means it has to be very much clear that we have to give the person a full perspective of the treatment we are giving it. Then procedure itself should be very much explanatory, which procedure we are taking into place. Everything should be given, including the cost, including the approximate time for healing, including the post-operative and post other thing, or recovery, or some disability, or even photograph, or the recording of the event. These all should be explained. After that, all these things happen, then the patient understands our language, then he or she can give the consent, give their assent for the procedure. A statement should be recorded in the language of the patient. It means that it is one of the prototype is here. I have no objection of undergoing medical examination, knowing that the result of my examination may go in my favor or against. This is the examination consent for the medical legal examination. With the signature, left thumb impression, attach the signature. Again I am telling, if the person is unable to write, a statement is recorded by some other person, read before him after recording, and left thumb impression of the person Consenting is recorded. Referred patient may report himself or patient's party or nothing is noted in this column. So should be is patient how has come is if a column is there we should write it, and if column is not there we should not write it, but we should write the number through which has the patient has entered into the hospital, and we should stick to that. Otherwise, patient may sent by some other following: by police authority. Generally, we get patient by police authority, by our order of the court, or by order of the government, or other designated person of administrative authorities, so that we follow certain order to examine the person. Brought by and identified by, statement of the person is recorded. It is Mr. X is being identified by me like this. We should record it in our report. Identifying person should also sign the and give the thumb impression. Identification mark that I have already discussed. It can be congenital mark, it can be acquired mark. Then we have a short history. We should be very much careful in taking the history, because history can be doctored or history can be misleading. Most of the time in our setup, in this area, we get wrong history, we get carried away by the history. So we should take the history, but we should not be get carried away, because we should be more relying on our findings. So we should give and we should take some idea from the history, and we should very much whether the patient was unconscious, unable to speak, incidents recorded in the language of the patient, how the incident was caused, time and place as per the person, how many persons were involved, weapon was involved. So these all we can get the idea of the incident from them. All the things we should be recorded, but should be interpreted and matched with the injuries also. Then the summary of the injury, alleged date and time of injury, brief history. We should write here brief history. Examine in the presence of, that is a witness. We should get the witness there. Female should be examined in the presence of female witness, and male should be examined in the presence of male witness. It is a common phenomena, and it should be where male doctors should be very much aware that they should examine a female patient in the presence of a female witness. General examination, again all the same procedures of general: state of consciousness, blood pressure, pulse, respiratory rate, SpO2, temperature, general scale, and we should be doing in the same manner. Systemic examination, again central nervous system, we should all fully examine the central nervous system. Cardiorespiratory system, we should fully examine the cardiorespiratory system. Respiratory system, intake, outtake and all that, and per abdomen we should all examine. Complete systemic examination should be done, and anything which is found abnormal should be mentioned here. Documentation of injuries. Now come to the local point where the injury has happened. Findings are noted in the following points. Type of injury, again abrasion is there, contusion is there, laceration is there, or incisor wound is there, or chopped wound is there. Whichever wound is there, we should write it. Shape is again important: elongated, oval, circular, irregular. Size is more important, because we should always write the size, how much size is there. So we should write the size into 3 centimeter into 6 centimeter like this. And length, breadth and depth sometimes is required. In some cases, it should be in India we should be writing in the centimeters, because it is easily and accepted norm in the centimeters. Position of body in relation to some fixed bony or other points, and this should be, suppose it is in the chest, then it should be whether it is from the midline here and midline here or from the upper side this there, again it should be related with the anatomical landmarks, direction, oblique, transverse or vertical, this all should be mentioned in the injury report. And the state of healing, sometimes an injury is injury phenomena especially in the children is a continuous process. It is he or she is beaten today and then tomorrow and then brought to the hospital, then we can find that different stages of healing or fresh injuries, and we should note all that, and we should document that the injuries are not of same age or same date. It is one of the phenomena, one of the chart: laceration, type of injuries, size of each injury, site of each injury, nature of injury, type of weapon, whether the weapon was dangerous or not, and any remark which we have given to that. If there is a laceration, size, then the site, forehead is there, then the type is grievous hurt is there. Weapon, mostly we can identify blunt weapon, it can be dangerous or non-dangerous, and bleeding is there or not. Bruise is there, then we have somewhere we have exam for radiological examination like X-ray and all that. Avulsion is there, it is maybe grievous. Then another is avulsion and swallowing of the leg. Swelling is somewhere is there. Then the radiological examination is there, X-ray is there, and then laceration is there, lower leg, grievous, blah, something. We should all be looking on this aspect, and we should all be very much clear that what is the site, what is the size, what maybe it is a simple or grievous injury, or what may be the possible weapon, and whether it is dangerous to life or not, whether it is further anything is worth mentioning it, or worth any further investigation. So these all columns are may be different in different format, so we should be aware of that, and we should not leave any of the things blank. This means this is blank here, this should not be blank, it should be something written here which is related to that injury. Blank should always attract some of the inefficiency. The court will say, the defendant opposing counsel can say that you have deliberately left this. So we should not leave any of the columns unattended that may attract to our point that we are negligent on that. Though we may not be negligent, but anything which is left blank, it falls on our part. This is one of the report template where various thing has written, but it is not in very good format. So I am emphasizing again and again, it should be in properly written format, properly tell the authorities to give the injury performer very clear, and it should be very much clear, and we should be able to write in specifically the performer based report, so that we should not miss anything, or we should not able to be none of the things should be misspelled, nothing should be misread. So it should be column based and column based, and it should be written in this form, and we should be aware of that. Photograph and documentation is very much important nowadays. People are not aware of that even the photographs, most of the time in our setup we have made mandatory of photographing the injuries, so that it can be further re-examined and further reassessed depending upon the conditions, and it should be also be a record of the medical legal report, so that it can be brought further into the light of the court using proper lighting and scale. And we should also, while taking a photograph of the wound or the injury, we should have a L-shaped scale. We should have a metering and measuring over it. Suppose the injury is there, and we should put it like that and take a photograph of that. So we can measure the size of the wound by photograph only, that how much is the size of the wound. So we should be carrying this L-shaped, is coming in the market, L-shaped scale. And L-shaped scale is there. Various types of scale, paper scales are available, and we should be carrying it and just put it there on the wound and the injury and take the photograph, so that all the documentation can be done in the later with good ample time. Close-up shots and detail examination should be taken. Our camera should be very good quality, so that we can further enlarge the pixels and we should see every detail of that. Written description, all the injuries should be clear and concise language. Avoiding subjective language should be avoided. Speculation should be, we should not speculate, because there is no space for speculation. We should be writing only which is present there, not by somebody's suggestion or by somebody who has documented certain injuries already. We just copied it. No, we should not. We should get all the examination by our own eyes and the all our senses, so that we should be sure that it is there. We should not go for the hearsay and all that. Contextual information should be all including relevant information should be there. Diagram and sketches, we are also now very much emphasizing that each and every injury performer should be having a diagram, so that we should be able to examine that and just locate that. All the diagrams in one page. It is the front side, just see that injury is there, just mark it there, and or injury is there, mark it there, or injury is in the back, mark is there. So injury in the hand, mark it here, or injury on the other side of the face, or you should mark it here, or mark it here, so that we should be very much clear. Injury report should be very much clear, and all the authorities should, or the other agencies should be very much easy in understanding that it is there, and we can further. It is easy to recall also. Sometimes as I already said, it is most of the time takes 10 to 20 years to come to the court. Sometimes I get summons from court after 10 years to 5 years to 10 years for a case which I have already done in 10 years back. Then I get call, and most of the time I don't remember of the case, but by going through the file of the case, we refresh our memories, and we should the more elaborate and more concise we will be there, and then we will be easily able to recall the incident, and we will be able to give the evidence in the court. Today's or our routine, we should make our habit of doing this thing, so that we should be very much clear in the future also, so that we should not be bothered in the court. This is an examination of dislocated X-ray of the finger. Another is fracture of the radius. So X-ray should be examined very properly. This is the developing X-ray where the bones have not fused. So this is the bones have not fused. So we should be going all through that. Again, there is a not complete fracture. Sometimes half fractures are there. So we should all be very much clear in writing in the report, supplementary reports. Here the fracture of the ribs are there, fracture of the ribs are there, we should be able to examine it, and we should be, it is in a child, there can be a battered baby or something like that, and we should be very much vigilant, and we should be very much get thorough and get ourselves sensitized for that. Another is gunshot. In most of the time gunshot, we find the metallic shadow, opaque shadow, and we should not directly write that it is a bullet or something like that. We should say that it is a opaque metallic shadow about this size present in this region and about this size, and similarly in that if there clear cut evidence is there is a gunshot, then we can also comment on that, but we should refrain from that. We should basically say that metallic opacity or something like that. Opinion. The following thing should be taking into mind that type of weapon. Sometimes we should just hint depending upon the type of injury, how much time has passed, means if the injury is already started healing, then the time has passed. The gravity of injury should be simple or grievous. This is the main motive of the most of the time police or the other authorities send to us for an injury examination, because they want to 319 or 320 on the or 307, or they have to chart the person in these IPCs. So if it is simple, they will put in simple. It is grievous, they put it in grievous, or under they can further add on 307 or other IPCs. So we have to get them at least certain clarity about it. Each injury is falling under which IPC, so that they can easily apply the IPCs and go for the legal proceedings. So we as a doctors or the medical health experts should be very good helping hand to the judiciary and all that. Again, the description injury that I have already discussed in that, it is one of the performers and the opinion is there. Then the signature of doctor, signature should be there. Then a designation is in capital and the complete name again in here in bracket in capital letter. Capital letter should be there. Complete name, date, time. These all should be complete here. And legal or ethical consideration, adhering to legal ethical guidelines in documentation of reporting, maintaining confidentiality, that is very much important for us, that we should not leak, we should not tell anyone, or our document should not be leaked from our office, and confidentiality should be maintained because it may be, if it is loose, then they can further lead the victim into further danger, or that is maybe life threatening also. Ensuring accuracy, impartiality, objectivity in reporting, we should be impartial in that. With this, we have come to this end of the lecture. Further, we have one more injury report, that is of burn, and our further course is that we will be having certain enlightenment or certain point on the insanity which can lead to certain injuries, and covering that into other with those things we can conclude our course, and we will be having further that course about regarding that. So we should be adhered to the medical report formation. We should go to the all the possible injuries can happen, or all the possible mechanism that can happen. So we have large context of the injury. We get daily the injuries, we prepare the injury reports, and we prepare the injury reports, and we get all the large data, large information due to our knowledge and deduction and all that, we come to conclusion that this injury has happened and this may be simple, this is simple, this is grievous, this endangers life. We have to read, recall, make our habit. We have to make our habit of doing a proper injury report, proper certification, and certain important finding. If we come with the further lecture, we will go for the autopsy also, certain autopsy procedure or postmortem procedure in certain other courses. We will go for complete autopsy guidelines, complete autopsy reports also in some other course, but this course is mainly related to the injuries and the preparation of the injury reports, and it's especially for the working medical officers or working the undergraduate who are going to be a doctor or already practicing the practitioner, so they can learn from it and they can get enlightened from it, so that they can prepare a good injury report, and there should be less error and minimize the time of the trial of the courts. With this, we come to the today's conclusion of the course, and we will be continuing further also.